Quick disclaimer, this is an AI voice, which is not going to be perfect. There is a transcript in the description as well as subtitles for you to read along with. There are two general elements for criminal liability, which are actus reus and mens rea. Actus reus is the act of committing a crime. This act must be done voluntarily for there to be a criminal conviction. There are two types of crimes that involve actus reus, which are conduct crimes and consequence crimes. A conduct crime is where a specific act is prohibited, such as smoking in a public place. A consequence crime is where the outcome of the act is illegal, such as death. A voluntary act is when an individual performs an act willingly or with control over their actions, as shown in Hill v. Baxter. An involuntary act or state of affairs occurs when there is no criminal act or intent, but a crime was still committed, as shown in R v. Larsenault. An omission is when an individual fails to act. There are 6 types of omission, which are contractual duty omission, official position omission, voluntary omission, relationship omission, dangerous situation omission, and statutory omission. A contractual duty omission occurs when an individual has a duty to act under their employment but fails to act, as shown in R v. Pitwood. An official position omission occurs when the individual has a position of authority or care and they fail to act, as shown in R v. Ditham. A voluntary omission occurs when an individual takes on responsibility for someone's care but fails to act, as shown in Stone and Dobinson. A relationship omission occurs when an individual has a legal duty to act due to a relationship that they have with another person, but they fail to act, as shown in Gibbons and Proctor. A dangerous situation omission occurs when the individual creates a dangerous situation and fails to prevent the harm that it will cause, as shown in R v. Miller. A statutory omission occurs when an Act of Parliament creates a duty to act, such as the Road Traffic Act. Causation is when an event or consequence is brought about by the defendant's actions. There are 2 types of causation, which are factual and legal causation. Factual causation uses the but test, which proves whether the outcome would have occurred without the defendant's actions, as shown in R v. White. Legal causation requires the defendant's actions to have a more than slight and trifling link with the outcome and for the defendant's actions to be a more than a minimal causation of the outcome, as shown in R v. Hughes. The thin skull rule means the defendant must take their victim as they find them. This means that if the defendant chooses a weaker victim and they suffer more harm than a normal victim would, then the defendant is guilty of the full harm that is caused. This is shown in R v. Bloor. Novus actus interveniens is an event that happens after the act of an individual which either causes or contributes to the outcome. There are 3 types of novus actus interveniens that can break the chain of causation between the defendant's actions and the outcome. The first type of novus actus interveniens is the act of the third party, as shown in R v. Smith. The second type of novus actus interveniens is the victim's own actions, as shown in R v. Roberts. The third type of novus actus interveniens is a natural, unpredictable event. Mens rea is the mental element of a crime. Fault is the guiltiness of the defendant's state of mind while the crime is being committed, as shown in R v. Cunningham. Intention is where the defendant desired a specific consequence to come from their actions, as shown in R v. Steen. There are 2 types of intent, which are direct and indirect intent. Direct intent is where the outcome was the defendant's main aim, purpose, and desire, as shown in R v. Mohan. Indirect or oblique intent is where the defendant saw the possible consequences as virtually certain but ignored the risk and continued with their actions anyway, as shown in R v. Woolen. The defendant may have been reckless in their actions, which is when an individual acts in a way that makes it more likely that harm will occur, as shown in R v. Cunningham. Negligence is the omission to do something that a reasonable person would do, or doing something that a reasonable person would not do. Negligence becomes gross negligence if the defendant's omission is so extreme that the jury must consider it illegal, as shown in R v. Anamarco. Strict liability are crimes that require no proof of mens rea. There are 5 criteria that are used to establish strict liability. The first criterion is to presume that mens rea is required for the crime, as shown in PSG BV Storcoin. The second criterion is that the more criminal the crime, the harder it is to remove mens rea, as shown BV DPP. The third criterion is that the statute must state or imply that mens rea is needed for the crime, as shown in Cundy v. Leclerc. The fourth criterion is that the crime must concern public interest or safety, as shown in Camo v. Tilstone. The fifth criterion is that the offence must impose a small penalty, as shown in R v. Howells. If the crime requires mens rea, which stated or implied by the statute concerns public interest or imposes a larger penalty, then the crime will not be strict liability. Transferred malice is where the mens rea is transferred from one offence to another. This occurs when the defendant intends to commit a crime against the victim but ends up harming a different victim, as shown in R.V. Pembleton. The coincidence of mens rea and actus reus means that the guilty mind and the criminal act must occur together for an offence to be established. A continuing act is when the actus reus and the mens rea occur at the same time, as shown in Fagan v Metropolitan Police Commissioner. A transactional act is where there is a clear series of events and the mens rea is formed at some point in the series of events, as shown in Thobomeli. Thank you for watching this video on general elements of criminal liability. I'll see you in the next lesson.